Hey.
solution by any legal mind. Meaning, the judge, are you trying to imply that the judge must decide your way? Or the issue is more of the language, which I think Judge Ibrahim had asked you about. Yes. Professional and courteous language. Yes. Yes. How are you going to ensure that you improve on that?
I will endeavor that our legal system is very adversarial. But when you sit on the bench as a judge, you're not taking sides. You're not on the side of the plaintiff. You're not on the side of the defendant. We advocates tend sometimes to be overzealous in defending our clients. But when you sit as a judge on the bench, you have to look at both rationally. And in that case, then you will not really lean on one side, and you will not then have to use such words.
Okay. And in another matter that you have shared, the sexual offences case.
Yes.
Your appeal was around sentencing. So, what are some of the considerations? I know as sexual offences matters are not, you don't have the original jurisdiction, but in matters that are seized before you in sentencing, what would you consider before sentencing in a criminal case?
I will consider the age of the accused person. I would consider their health situation. I would consider their remorse. Are they remorseful? I would also consider the circumstances under which or in which the offense was committed, and particularly also the age of the victim. Yes.
Okay, at appeal level, when you're setting aside or reviewing the sentence in a sexual offense matter,
I would consider that. I would consider whether the accused. I would consider whether the accused in his evidence or in his defense raised the issue of the age of the minor. I would also consider the mitigation that he gave, and I would also still consider his age.
Okay, in your submission, among the things you have asked the court to consider,
yes,
is that the complainant, that is a 15-year-old girl,
yes,
the complainant admits having been friends with the appellant and went to meet him on her own volition. And then part 4, the complainant, that is now the 15-year-old girl, having not contracted any disease or fallen pregnant, but was able to proceed with her education. Why do you think those two issues that I've read out, the court should consider those two issues?
Yes, the impact of the offense on the victim.
Yeah, but this one you're asking the court to consider to reduce the sentence for the accused person, the convicted person. Why is it necessary for you to consider not the victim, but in terms of reviewing sentence?
The impact on the life of the victim is important.
But here you have asked the court to consider these two issues. There are 4, but of particular concern are these 2 in reducing the sentence of the convicted person.
Because they were not considered in the trial court.
Why is it necessary to consider that a person was not did not fall pregnant, neither did they contract a disease as a mitigating factor before sentencing? Why is it important to you? Because that is what you have put in your submissions for review of sentence.
My consideration was the fact that the victim will somehow be able to salvage their life. As opposed to the harsh sentence that was handed to the accused person by the trial court.
Okay. It is said that the Kenyan judiciary is not pro-poor, and the Constitution requires all of us to promote quality. And Bangalore principle of judicial conduct equality is among the principles. So in interpreting the law, how are you going to ensure that you inculcate the principle of equality in your decisions?
By making decisions that cater for the social and economic circumstances of litigants appearing before me, by considering their cultural background and age, gender, and even the economic status. Thank you, Chair. And welcome again, Agnes. Would you share with us how does the judiciary contribute to the national development goals of this country? Very briefly. Yes, strong judiciary encourages, or rather ensures, the strong economic situation of a country. If investors are confident that they can do business in this country, and where disputes arise, particularly in contract or even in their investments, that they're going to get a fair and reasonable decisions, then it puts ahead our economic situation. The judiciary also has come up with other alternative dispute resolution forums like mediation, which ensure that disputes are resolved within the shortest time possible, and that makes for a strong economy of a country, and people are able to do thriving business. The judiciary also promotes the constitution. In a country where the constitution is promoted or given strength, then the economy of that country will definitely thrive. Okay, my second and last question is that explain the role of the judge today, how it has changed from that of a traditional judge as we have always known it. The judge has an obligation to developing the law, promoting the constitution. The role of the judge is not just as an arbiter of the law, what has changed. Yes, the role of the judge has now, there has been realized the need for empathy. And the judge is now recognized as a strong pillar of society and even the economy of the country. Yeah, and the role that ICT plays in the role of the judge. Yes, yes. ICT ensures that there is faster delivery of justice, and that there is easy access to justice because decisions are easily available and the court system is readily available. Thank you, Commissioner Rand.
Thank you, Chair. Good morning once again.
Good morning.
Okay, if you're successful to join the bench as a judge, you will find occasionally you will encounter advocates who, for lack of a better word, I'll describe as cantankerous. You know, those who come and they do not want to listen, they want to take charge of your court, they want to direct how you're going to conduct proceedings there. How do you purpose to deal with such advocates, or even parties for that matter?
Thank you, Commissioner. I would first and foremost ensure that I conduct myself with decorum, because what you give is what you get in return, although sometimes it doesn't exactly work that way. I would take up measures by ensuring that if an advocate is, I will take up measures to ensure I have full control of my courtroom. I will not give room for people to express their private or their personal side in my courtroom.
Those measures?
I would make use of the court bailiffs and other staff to make sure there is order in the courtroom, and I would constantly make reminders that of the need for decorum in the court, so that we can move towards a speedy resolution of disputes. I would make use of the court users committee to sensitize advocates, particularly, and even litigants, on the importance of maintaining decorum in court.
You will not have difficulty stamping your authority and taking charge of your court. You don't see yourself having difficulty?
I will not.
Okay.
I will not.
Okay. The second question I have for you, you are currently operating your own law firm.
Yes.
How many associates do you have?
Currently, I do not have any associates in my law firm.
Okay. Yes. And just giving a rough estimate, what is your workload like?
In terms of litigation,
yeah, the cases you have? Yes.
I am in court at least 3 to 4 times in a week on either applications or full hearings. I have mentioned
roughly like how many cases you have, the nature of clients you majorly attend to. Yes, that's what I want to hear.
I mostly deal with individual clients, one-on-one, not as opposed to corporate clients. I have a big portfolio. I lost count at some point. And my law firm has grown from clients referring other clients. I can say with confidence that at least every client I worked for has brought back at least one other client, and that is how my law firm has grown.
Okay. Yes. Do you have a performance measurement framework in your law firm?
On myself, I have targets.
You're not alone in the law firm, are you?
No, in terms of advocates, yes. I am the only advocate in the law firm.
But you have other staff?
Yes, I have a secretary who also serves as a receptionist. I have a court clerk. The measure for my performance is actually something that I do according to my targets. As for the staff, I gauge their performance, and where there is need, I call them and have a talk with them on how
what do you use to gauge? You just look at how they perform. Are there instruments you use?
First of all, I believe in discipline. I'm a strong upholder of discipline and timeliness. I believe that if you're not able to keep your time, I think you may have challenges performing your work to required standards, because then if you, like, for example, you come into the office at 9 and you're required to be elsewhere at 9, you're not performing. For me, it's on a day-to-day basis.
Yes. Okay, now, before we embarked on this exercise, we engaged some of our stakeholders, yes, just to get a feel of what they want, yes, in the kind of judges we are to recruit. Yes. One attribute that featured strongly was that they needed someone who's a hard worker. Yes. So now what would you use to persuade this commission that you are a hard worker?
I have submitted testimonials, which are mostly from people that I have worked with. But on myself, I diligently perform work that is given to me by clients, and that explains the natural growth of my law firm. Like, I have not had to go soliciting for work or such like things. I believe in delivery. I believe in substance and delivery of substance. Yes.
Now, lastly for me, under Order 11,
Yes.
we have the case management conference.
Yes.
At the end of that conference, that procedure, can you give us 3 kinds of orders you are likely to issue as a judge?
I can request parties to amend their pleadings if their pleadings are not proper.
More like the final orders you will be making at the end.
At the
You
end,
see, when they amend, you're still at the stage of pre-trial, isn't it?
Then
You still look into those amended pleadings. I'm talking about at the end of the exercise, the case management exercise, 3 orders you're likely to give.
certify the matter ready for trial, give a hearing date, or give directions as to speedy prosecution of the matter. Like, for instance, can we dispose of this matter by the written submissions?
Okay, that's not what I was looking for, but yes. Any other?
At the end of pre-trial, I might as well, I might also require for, that is discovery and all that have been done.
That's what you do in the pre-trial.
Yes.
Yes.
I might refer the matter to, I might decide my court does not have jurisdiction.
Okay, thank you. Yes, thank you, my lady.
Commissioner, Excellency.
Thank you very much, CJ. Now, can you tell us the guiding principles of leadership
Thank you, Honorable
and
Commissioner.
integrity?
Sorry?
Leadership and integrity.
Diligence, efficiency, timeliness,
Specifically as in chapter 6.
competence, integrity, honesty.
Okay, and now, in leadership, what would you consider as transformational leadership style under a one-side person?
What I would consider my transformational, please say again.
Would you consider yourself as a transformational leader?
Yes.
Can you explain?
Because I am a person who likes to see progress in society, and I have a keen sense of responsibility. I always take charge of my civic duty. Like, for instance, I will participate in every general election, the Law Society elections, or any other forum where I'm required to exercise my civic duty. I participate in community development. I help the less able members of society, not just by giving them money, but considering the fact that I'm a lawyer and I have come across quite some experience and knowledge, I am able to volunteer to render advice to members of society, even when there is nothing to be gained from it.
Thank you, CJ.
Thank you, Honorable CJ. Good afternoon, good morning, Honorable
Good morning, Honorable Commissioner.
Okay. As a follow-up question from what Commissioner Rito has asked, maybe you could tell us what integrity means to you.
A person of integrity is a person who is not likely to be swayed by selfish or self-persuasions, who will deal with given set of circumstances, regardless of whether the outcome favors them. In a sum, to say a transparent person. Transparency.
Would you consider yourself, or would you term yourself as a person of integrity?
Yes, I am.
Okay. The question about guiding principles of leadership and integrity, maybe you will need to go back and refresh yourself on those ones. Please tell this commission, have you ever come into any conflict with the law in the past?
At a personal level?
At a personal level, yes.
No.
You've never come into conflict with the law? Any other way?
Not that I can think of. No.
As we do background vetting for candidates, we work with different agencies, different government agencies to provide us with reports, and you're also expected to do that. Have you cleared with the different government agencies that we work with?
Yes.
Have you encountered any issue?
No.
Okay. My other question to you would be regarding corruption in the institution. Judiciary is seen to be a weak link in the fight against corruption. What is your view on that?
As much I will say there is room for improvement, I know for a fact that the judiciary has really evolved from what it was before, and we as advocates actually feel the effects. The levels of corruption have drastically reduced, and I believe it's a work in progress. Yes.
If you're successful and you become a judge, what are some of the measures you're going to put in place to ensure that these incidences are eliminated or reduced?
Incidences of corruption.
Corruption in the institution.
I would start by sensitizing stakeholders, and that is court users, the subordinate staff, and my colleagues even, on the vision of the judiciary that we are undergoing a transformation, and we cannot be accused of corruption anymore. We need to move forward from that.
So sensitization is the only way? Any other way?
Myself, I would make sure that the system is foolproof, particularly in the station that I'm handling. I would make sure that all the systems are transparent in a way that leaves no room for corruption.
How do you do that?
I am used to taking charge at my practice. I am used to taking charge of each and every work that goes on, and I would really supervise in a way that anybody who might be tempted that way feels challenged. I sensitize people regularly that, you always be honest even when one is looking. Apart from sensitizing and then putting systems in place, I would ensure that myself, the way I handle myself, leaves no doubt that I am beyond corruption, and I, in the hope that that might inspire others to follow.
Okay, thank you. My final question, as a leader and as a judge, if you're successful, how are you going to advocate for diversity and inclusivity in the institution?
Again, I will use the word sensitization. and by sensitizing the community or even the people around me on the importance of supporting each other regardless of your age, your gender, because I believe that whether man or woman, it is only if we support each other that we can go forward. I also, by encouraging or supporting the weaker members of the society that we are living in.
Okay. Yes. Any other?
Also information, giving information, really.
Why do you think it's important to advocate for diversity and promote diversity and inclusivity?
Because I believe that everybody has something to contribute, even the weakest member of our society.
Any other reason?
And it's also because our constitution, it is my duty under the constitution to uphold diversity.
Okay. Yes. Thank you, Honorable CJ, and I wish you all the best.
Thank you.
Thank you very much, Ms. Joroge, for having yourself for this interview. I think this brings us to the end of the interview. We will contact you when we complete the exercise. But before we release you, we always give a candidate an opportunity to ask us a question if you have any.
Thank you, Honorable Commissioner, Madam CJ. I do not have any question, but I'll take this opportunity to thank you all for having me and engaging with me. And I also wish you the best as you look for the right candidates to steer our judiciary ahead. Thank you.
Thank you, and keep up the good work that you are doing in private practice, representing clients in our courts.
Thank you.
All the best. We'll get in touch with you.
Thank you.
to attend specialized courts like the Environmental and Land Court, the Employment and Labor Relations Court, and also I have matters before the High Court. The bulk of the matters are under the Commercial Court, the Civil Court, and the family-related matters, my lady. I've also appeared before the Chief Magistrate Court and also including the Small Claims Court, my lady.
For that, and what are your attributes? If we were to ask you, what do you bring on board if you were to be the successful candidate?
My lady, by virtue of the kind of litigation that we handle, I would first point out that the key achievement that I've been able to bring about is a contribution to jurisprudence. If you were to look at my CV, my lady, there are total about 30 reported cases. Right from the year 2017, there could be more, but I constrained myself to the period of 2017. So I have contributed to the jurisprudence in not only in commercial, but also land matters and also the civil matters, my lady. And the key attribute I'll be bringing, my lady, is I will be bringing efficiency. Why do I talk about efficiency? You do realize that as a practicing advocate, that the tool I have been using is Order 11 in terms of ensuring compliance in all of my matters. And you, once you're compliant in terms of filing your, for example, your witness statements and documents, you're actually ready to proceed with the matters. And that, my lady, has contributed to me actually concluding matters at a very high rate.
So you bring efficiency?
Yes, my lady.
Anything else that you bring on board?
I would find myself as a team leader. Currently, I work in a supervisory role. I have court assistants and also have pupils who are working under my lead, and I'm able to, and I'm glad to report that since I was given this role in the year 2020, I have been able, there are two advocates who have been able to mentor, and currently are practicing and actually practicing well, my lady.
Very well. And finally for me, of course, having been an advocate from the year 2008 and practiced in our courts,
yes, my lady.
I'm sure there are certain attributes that you see amongst the judges or judicial officers that you think that if I become a judge, I am not going to be like Mr. or Miss X.
Yes,
what
my
are
lady.
those?
My lady, my concern would be perhaps on a competency level, because you notice that some of the judgments and rulings that are churned from some of our courts do not really articulate the issues that have been raised by the parties. So if I were to become a judge and given that opportunity, my desire would be that I would be able to churn qualitative and quantitative judgments. Then too, my lady, I have seen some magistrates or judges who are temperamental. They're not really keen to hear the sides of the parties, and they're quick to make decisions. And my lady, in that front, if I were to be given an opportunity, I would desire to have a listening ear, to listen to everyone's views before making proper directions in the matter, my lady.
Thank you. I want to clarify which area of law is your friend?
I have a lot, my lady. I have commercial, I have civil, and I have family-related matters, and employment matters, and also land matters, my lady. And also, yes, my lady.
Yes. Under the Constitution,
Yes, my lady.
just tell us which orders can be issued if one were to file a case seeking the determination of fundamental rights.
My lady, I will be guided by Article 23 of the Constitution, and we have various reliefs under that that article. That would be the order of injunctions. Would be able to issue conservatory orders, an order for compensation, an order for habeas corpus, and a declaration declaring a law perhaps invalid, and declaration of rights. And one that is not purely stated is statutory interdicts, as guided by the Vitubel case.
Yes. And what circumstances do you issue statutory interdicts?
My lady, I believe it is instances where you're giving supervisory orders, especially, for example, where the government has breached certain articles in the Constitution. So my lady, the court will actually be giving directions in terms of, number one, articulating the kind of breach that has been occasioned by the government, how that breach can be rectified, and my lady would be also given an action plan on what needs to be done so that that breach can be rectified, my lady.
The next set of questions will be asked by Justice Madam.
Good morning.
Good morning, my lord.
I heard you speaking that you are very efficient in handling cases and you rely on Order 11. And in one of the cases you cite, the case was actually dismissed for want of prosecution. What went wrong?
My lady, this is a matter that actually was given to me a few days. It was actually being handled by another advocate. But then again, I would not want to lay blame on that. I think as a firm, we did not utilize the bring-up system too well, because had we done what we were supposed to do, that matter, my lord, would not have been dismissed. It was a bit of negligence on our part, okay. I must admit.
Secondly, I've looked at your CV, and on pro bono activities, you say regrettably, I have been unable to commit to pro bono activities as my availability for such activities is contingent upon discretion of my employer, which has limited my ability to participate.
Yes, my lord.
So, for the 15 years you've been practicing, you have not been involved in any pro bono activities?
Unfortunately, not my lord.
Have you had, like for example, I'm sure you go to church?
Yes, my lord.
And you don't involve yourself in pro bono activities? What do you understand by pro bono activities?
I think my understanding, of course, is that you're giving free legal advice to those who are unable to, get that service.
Is it limited to free legal advice?
I think when I was answering that question, my lord, I was a bit narrow-minded. But of course, in church, we have members who actually come and seek for legal advice. But I don't think in that aspect. Yes.
And as a judge, why do you think it's important that you, why do you think we emphasize pro bono activities for this position? Why do you think it's important?
My lord, it is important because everyone has a right to access justice as guided by Article 48 of the Constitution, and also as guided by Article 159, where everyone is supposed to access justice regardless of status, my lord.
Okay. Finally, you've heard of the Small Claims Court.
Yes, my
It's
lord.
an important door to justice.
Yes, my lord.
Can you just tell us some of the controversial issues that have been made in regard to
I think I will point out one that is most recent, my lord, where the court stated that the Small Claims Court does not have jurisdiction to handle what you call personal injury claims. My lord, the reasoning behind that judgment was that based on two issues. One is the aspect of service of notice under Section 10, subsection 2 of Cap 4.5, and also the aspect of general damages you cannot quantify.
And so what is your view?
My view is I am not really in agreement with that, because there's a reason why that statute provides that that court can hear personal injury claims. My lord, if you were to look at the nature of personal injury claims, for example, soft tissue injuries, I am yet to come across a judgment that is beyond 1 million, because when you look at the pecuniary jurisdiction, it is not more than 1 million.
That's good enough. Finally, as a High Court judge, how would you support the Small Claims Court? How would you support the Small Claims Court?
You notice that the small claim courts usually have a limited number of days within which to conclude their matters. So, my lord, if at all there are matters that emanate from the Small Claims Court on appeal level, then that it will actually be befitting if one is able to conclude their matters in the shortest time possible, to give meaning and effect to the Small Claims Court Act.
Okay, thank you. Thank you very much.
Thank you, my lord. Thank you, my lord.
Now, I've read your sample writings.
Yes, my lord.
Thank you. I've read your sample writings. They're very concise. And when you were, most of them is where you're acting for parties. I've seen for the respondent, for the petitioners, and so on. You are speaking to the judge or the magistrate, the judicial officer. But now as a judge, how do you think you would like or you intend to present your rulings of judgments? How do you structure your judgment, for instance?
Okay, first of all, I would start by setting out the issues that have been laid out in the various pleadings. For instance, for example, I'll start, for example, with the plaintiff's case and the defendant's case. I'll be able to bring out the factual issues and what exactly is the cause of action. Then upon doing that, my lord, I will be able to analyze, of course, the facts in tandem with what the law provides and be able to make a informed conclusion and do a balanced effect on the outcome.
After giving the background, and the parties' brief cases, you will finally go to the issues, right?
Yes, my lord.
Yeah. How do you identify the issues?
The issue will be guided by what is contained in the respective pleadings, my lord. By the cause of action and, of course, the reliefs that have been sought, my lord. Yes, my lord.
How do you deal with preliminary objection on a point of law?
My lord, it behooves of a judicial officer to deal with that issue first, because you do realize if the court does not have jurisdiction, then you have no business in handling that matter. So that would be the first thing to handle before any other issue is handled, my lord. And if you find that you do not have jurisdiction, then you will not have to proceed with all the other issues that have been mentioned, my lord.
When you're writing a judgment, whom do you think is your audience?
My audience is the public. But this in this
You're not the judge first?
audience.
Yeah, I mean, meaning the person who should understand what you're saying.
Or I should be the first person to understand what it is I'm reading and be able
No,
to...
you are presenting to... Okay. Yeah, you're writing as a judge.
Yes, my lord.
But no, when you are writing as a lawyer, you're talking to the judge. But now, as a judge, you're speaking to...
I'm speaking to the litigants, my lord. Other than talking to myself, I'm also speaking to the litigants and also the public in general, because there are people who will also have contact with those judgments and rulings. So I'll have a whole spectrum outlook, my lord.
And you know your cases will be reported?
Yes, my lord. I'm aware of that, my lord.
To what extent will you use legalese? Like terms like stare decisive, what is the duty to the public?
My duty to the public would be to, as much as yes, these are legal terms, it behooves you as a judge to be able to explain why are you saying res judicata. What exactly does it mean? When you're talking about all these other Latin words, you also have to bring it down for the people, because you remember they also have a right to actually, when they're looking at this judgment or ruling, they have the opportunity to understand what it is you're trying to put across, my lord.
Finally, is a judgment, the way you present your judgment, deliver, is it part of access to justice?
Yes, it is part of access to justice, because once you deliver on a matter, that would mean you've put a sort of finality on the issue. Because remember, when litigants are coming before your court, they're coming to seek for a solution, and they're hopeful that once they go through the judgment, that they'll be able to get guidance on what to do next upon delivery, my lord.
Thank you. I wish you all the best.
Thank you, my lord.
Thank you, Chair. Good morning once again, Council.
Good morning, Commissioner.
Just picking up from where Judge Ibrahim has left, I do agree with him that you write well-reasoned pleadings, and I must commend you for that.
Thank you.
I also want to raise an issue with the use of exclamation marks in your pleadings. And just picking excerpts from Daily Journal, they say when you use exclamation marks in judgments or any legal documents, it's equivalent of barking at a judge, shouting, or gesticulating wildly. What are your thoughts around that? Because I've noticed you use quite a lot of exclamation marks in your documents.
Maybe perhaps I should start by saying that my why I use exclamation marks actually is to bring out, is to more like saying emphasis added. But I also appreciate the nature of the remarks that have been made in the article. I think I'll be more careful and going forward. Thank you, Commissioner.
My second question, again, just a quote from Judge Amy Barrett, think during her confirmation hearing, she had to say this about a judge. A judge must apply the law as written. Judges are not policymakers and must be resolute in setting aside any policy view they might hold. What is your thought around that quote?
To some extent, I agree, and to some extent, I do not agree. Because what would happen, for example, if you're handling a constitutional matter, and especially in, for instance, where you have, I'm sure, Commissioner, you're aware that where some provisions have been made unconstitutional, I think as a judge, if you were to apply a purposive approach and in tandem with Article 259, I think as a judge, you cannot be narrow-minded. You have to be progressive in how you do your judgments.
You agree with it? You do not agree with
Yes.
it? How about the issue of you agree with it? So you're saying it's 50-50?
Yes.
So kindly expound more.
To the extent that I agree with it is that also you, as a judge, you must realize that you should not, because you see, Commissioner, when you're talking about policy making, that is not the duty of a judge, because that would mean you are actually overreaching your mandate. And there's a question of separation of powers, because everyone should be able to work within their confines, Commissioner.
Lastly, is that Kenyans today have woken up to news, the Daily Nation, where the U.S. Trade Representative has stated that there is corruption within the judiciary, and if you allow me to quote, is that while judicial reforms are moving forward, bribes, extortion, and political consideration influence these cases. As such, foreign and local investors risk lengthy and costly legal procedures. End of quote. How does corruption interfere with judicial independence?
Commissioner, it does interfere, because that would mean that you're actually trying to, because my lady, Commissioner, let me put it this way. When you're actually bribed, that would mean that I have to play to your tune. And that would mean that I am deviating from what I'm supposed to do rightly, so that where I was supposed to rule in a particular matter, if we were to go to be straitjacket, then that would mean that the way I think is interfered, and I'd have to look the other way, and that would be an injustice to the litigants or those people who approach the court for help.
And how would you then promote decisional independence at the same time promote accountability?
For me, I think, for example, I do appreciate that judges have, for example, they have what you call the researchers. And for me, as much as, yes, judges have researchers, it is a question of appreciating what the research individual has done and be able also to make my informed decision. Because I think it will be a sad state of affairs where you're being guided, yes, and you're using 100% what the researcher has done. So it boils down to me as a person, as an individual, doing what I need to do, and that is being independent. Yes, I appreciate the work you have done, the research that you have done, but I have to come up with my own way of thinking, Commissioner.
Sure.
Thank you, Honorable Chair, and welcome again. Thank you. Now, when we were preparing for this exercise, we had a session with the stakeholders, and they told us that they would want a judge who understands the complexities of the judicial system, including the challenging environment and the power dynamics. Do you agree with that, and why do you think it's important to have that understanding?
It is important to have that kind of understanding, Commissioner, because you do realize that when you're serving litigants, when you're serving the advocates by extension,
First of all, do you agree that there is complexity in the judicial system?
yes, there is complexity in the system, and therefore it is important that you have an individual who understands the dynamics, who is actually judge ready and will be able to hit the ground running, and so that any matter placed before that judge, they'll be able to handle, however technical, however complex, of course guided by the relevant statutes and the constitution, they'll be able to handle. Because, Commissioner, if you were to have a situation whereby you have judgments that are not jurisprudently correct, then we have a problem. Because that will boil down to access to justice, because that will also waste time and resources, because that would mean you have to go to a higher court to be able to rectify the wrong that has been done.
Okay. Now, judiciary has been on a transformative journey. Just briefly tell this panel the kind of the transformation that judiciary has been undertaking, and how would you support this?
Okay, I am alive to the fact that there's what is called this social transformation to access to justice, which is, I think, a 10-year blueprint on the vision of what the judiciary will be in the next 10 years. What has been notable, Commissioner, is the utilization of ICT, and I'm glad that on the 11th of March, that with the guidance of the Honorable my lady Chief Justice, there was a rollout of the e-filing in all the court stations. And to what I note about the ICT, I also note that there is a dashboard where there will be tracking of court activities in terms of why are there adjournments, for example, was it necessary to give an adjournment, in terms of how many rulings and judgments have been delivered by a particular judicial officer. And Commissioner, that is a step in the right direction, because when you have ICT as a component of for the service, for litigants to access justice, that actually is an enabling factor under Article 48, where everyone has the opportunity to access justice. And justice will not be made by virtue of the fact that you're actually in America and and that you have to travel. You don't have to travel. You can actually access justice at the comfort of your seat, Commissioner.
But what risk?
I think the highest risk in as far as ICT is concerned is the element of data protection. Because that means you have to put up a system that secures the kind of data that is in the system. Remember, you have e-filing, you have judgments and rulings, and you have all these other aspects, like, for example, maybe payment of bail or bond. And security, it is a security concern. What if there's an outsider who tries to infiltrate the system? That would mean that the information that is contained in the system will be out in the open, and I don't think that would be the intention of having an ICT component. That would be the greatest risk. So in terms of how to mitigate, I think here would have to have experts and professionals who, I think I liken it to, for example, a banking system, whereby the bank holds a lot of money, and you see, if they don't put their systems right, the monies that are being protected or being held on behalf of the customers will be diversed to other third parties who are not supposed to be beneficiaries of that money. So if you have an expert to try and protect that interest, that would be a step in the right direction. Chair, good morning once again. Good morning, Yona.
Yes, I was listening to you earlier, and you alluded to a bring-up system. The law firm was explaining what went wrong with one of the cases that you had cited.
Yes, Yona.
Yes, could you just briefly describe for us, if you have one, the performance measurement framework the firm went to work?
It's not clearly documented, but this is what we do as a matter of practice. Every week, as advocates, including my direct supervisor, what we do, we generate reports on a weekly basis, where it is into it breaks out two issues. One, the kind of court activity you had. For example, if you had a hearing, you had an application or a mention, and what kind of directions were issued. Then two would be the aspect of what kind of pleadings you have generated, in terms of if you have you done an application, have you done a plea to Order 11 compliance. That is the best we have in terms of performance. So that at the end of the week, on Friday, we all converge at the boardroom, and we have a discussion on the matter that we've had and progress to be made going forward.
Yes. So if today we wanted to know how you're faring, I wanted to know how schools, the framework that you have, that is not to demonstrate to us how you work, how would I get that information?
Then that you would have to get it from my direct supervisor. But unfortunately, we don't have a framework where you say that, for example, in the month of January, I was at 90%, and in February at 30%.
So it's
have
basically
that
just
kind
a
of
reporting system?
Yes.
It's just a reporting system.
Yes, Your Honor.
Okay. You mentioned earlier the areas of work that you practice, or rather the areas of law that you practice. And I just want, because you see, if you're successful in your bid to become a judge, tomorrow you may find yourself presiding over a criminal court.
Yes, Your Honor.
Or at minimum in the criminal division where you only be handling criminal work.
Yes, Your Honor.
So I expect you must have appraised yourself in the criminal aspect of that, because it looks like you do a lot of civil law.
Yes, Your Honor.
Okay. Could you tell us, if you were to do case management in a criminal case, what would you be looking out to achieve?
I will be looking out to achieve a situation whereby you're able to conclude the matters in good time. And of course, I would be looking at the rights of the accused person as guided by Article 15, Sub 2, where, for example, the accused person has a right to access the documents that would be utilized in the hearing, so that once that aspect is concluded in terms of they have everything they need for the hearing, then would easily progress with the hearing. And of course, once you are done with that compliance stage, then you're able to take a date for the hearing.
I'm interested in the compliance.
The compliance stage.
So you have ensured that the accused person has the documents that the prosecution will rely on. What else do you look out?
I would also look out whether the accused person understands the language of the court. Because if they do not understand, for example, if from an ethnic community does not understand the English of Swahili, that means you have to ensure that there's an interpreter so that the accused person can follow through the proceedings. Then there's the aspect of bail and bond. You also have to look at that aspect, because you will also have to give reasonable bail and bond terms, so that you also secure the attendance and also some level of freedom, even as they are waiting to articulate their issues before the court.
Any issues concerning the actual trial that you would want to address at that point?
Maybe something to do with if there is an objection about confessions, then that would be an issue to consider. We'd have to do a trial within a trial to actually establish whether they have that confession was properly secured. Yes. Okay.
And I would like to know your role in leadership. Specifically, I would like you to describe your key achievements as a leader, and that is the specific achievements that can be attributed to you.
Okay, I think I will bring out perhaps two issues. As I earlier mentioned, Commissioner, I have those who work under me, and I have what I call a mentorship. Though it is not really programmed, but I have a mentor, those who are working under me, and I have been able to provide them with guidance on how to go about their duties. And other than that, when there's conflicts that normally arise, like most recently, where there was a problem with how some of the team members were relating, I had to quickly come in and to resolve the issue so that we have a seamless way of working and ensuring that all the advocates are able to get the service that they require. Other than that, Commissioner, I also secure leadership in how I conduct my dockets. In fact, if I were to inquire for my direct supervisor, I'm actually the lead in terms of being organized and being a timekeeper, and that, Honorable Commissioner, is leadership, because it inculcates that you have to be a timekeeper in order to be able to do your duties well, and also efficiency, where you're able to do your work well and in a manner that is pleasant before your supervisors and also to the clients. Yes. And also I've also shown leadership in terms of jurisprudence, as I've earlier stated, where the reported cases about 30, Commissioner.
What's the difference between a visual
example, if you'll allow me to use the third blueprint, where a visionary leader will come out with a template, and I've called the third blueprint as one that has come out from a visionary leader, because these are things that you want to see in the 10-year plan, that you have steps that you want to undertake to be able to make the institution better, to make it more efficient, to be able to make it more responsive. So when you're talking about vision, it's about what steps are these that you're taking to be able to take the institution or the people you're working with to a higher level, achieving also excellence in the process. One who is not visionary he just wakes up in the morning and just does as they wish, with no structured way of articulating their duties. Thank you, Commissioner.
Thank you, Honorable CJ. Good morning once more.
Thank you. Good morning.
I'm going to ask you questions around Chapter 6 of the Constitution that talks about integrity and leadership. And maybe you could start by telling us, what does integrity mean to you?
According to me, integrity means working, simply put, I think I'll put it as working in an honest manner, devoid of any interference from third parties. That is how we'll simply define it. And then, of course, if you want to be guided by Chapter 6 of the Constitution, there are certain principles that will actually guide you. One is you have to work with, number one, honesty in the execution of your duties. Number two is that if there's any conflict of interest, you have to bring it up as soon as possible. Three, you have to act with impartiality in the execution of your duties, meaning that you must not show favoritism or nepotism or bias. And then fourthly, you're able to excellently give services to the people. Remember, as a judge, you're required to serve the people, and therefore it behooves upon you to be excellent in the delivery of your services.
Thank you for that. Maybe you could tell this commission over time when your integrity was put to test and how you went about it, and perhaps any lessons that you drew from the situation.
Thank you, Commissioner. I think the closest that I came to is when I was working with the firm of Kinyanjui and co-advocates. And during that time, I used to do a lot of what you'd call running down matters. And we had a policy that when you're doing such matters, you have to ensure that all the bakers of the documents are availed. So there are certain regions where the advocates, I will not mention which regions, where they would actually come to you and say, instead of us producing these documents, for example, the police abstract, the medical reports and the treatment notes, for example, because there's an expense attached to bringing these witnesses, why don't we instead give you this money, and then you will not have to, and then we will now proceed with the matters and produce the documents by consent. So at that juncture, I do remember and I do recall that I was in fact, I was not amused. And I insisted that you have to bring all your makers, and I was not interested in the money. This was the closest to me being compromised. And I had a duty to my client to ensure that their policy was actually adhered to by ensuring that all the makers of the documents were availed, and that I had to cross-examine them at that particular point. What I have learned from this Honorable Commissioner is that in the execution of your duties, you have a duty to be a person who is honest in their dealing, so that if there's any atmosphere that wants you to deviate from the path that you have taken, you should quickly avoid it, because it has an effect in your practice, because it will boil down to when you're called upon to serve in any other institution.
So some of your actions will then bring conflict.
Yes.
With the people you work with.
Yes,
How
yes.
again do you go about it?
In terms of conflict management, if you can rephrase the question, sorry.
When you find yourself in such a situation, you're bound to have conflict with the people you're working with.
Yes.
How would you deal with that situation?
I think for me, I would have to bring the issue to my direct supervisor to be able to intervene and to be able to guide on the way forward. That would be, for me, would be the best approach.
Okay. Yes. You wouldn't want to handle it by yourself?
I can, because remember, as I said, I have tried. I have made it clear to you that I do not accept such kind of conduct. So if you keep on insisting, actually it's at the point of you insisting that then I will escalate it to my superior.
Okay. Thank you. Now there's judiciary has received attacks from external stakeholders where the institution is seen to be corrupt. What is your view on that?
I think it's more of a perception because my proposition on that would be, if you have a feeling that the judiciary is corrupt, kindly bring that evidence before the right authority, so that once that evidence is received, then they can be able to act on it. But when you're busy doing that in the newspapers and in the media, it is of no use. If you want to be useful, tender the evidence, and the evidence will be looked at, and it will be, if there's any probable cause, then it will be acted upon. Yes. Yes, my lady.
And that the position of a judge also entails leadership qualities.
Yes, my lady.
If you are successful in this application and you accept to our station as a judge, I want you to tell us at least 5 things you would do to organize your court so that the court is efficient. In terms of clearing backlog, in terms of delivering judgments. Yes.
Okay. First things first, my lady. What I would do is I would have to convene a meeting. Remember, there are people who already are there and they have worked in that environment. So first things first would be to convene a meeting so that I'll be able to understand and appreciate where they are, and so that once we're able to discuss, I'm able to look at that. I will have a meeting. Then two, we'll be able to analyze the key areas. For example, what are the problems, what are the challenges? Because if you don't do that, then you're not able to come up with solutions. So, yes. Yes, then third would be providing a solution. For example, if it's a question of backlog, where is there backlog? For example, if in a commercial court, you would find that the stumbling block usually is interlocutory applications. So is there a way we can go around without having to hear the interlocutory applications? Let us go directly to the hearing, so where parties can do Order 11 compliance, and then we'll be able to take dates for the main hearing of the suit. Yes, yes, as opposed to applications. Then fourth, I would also employ the service tool. I have been a beneficiary of the service tool, not all, perhaps maybe on appeal matters, where if you are able to give clear directions from the one, even before they appear before the deputy registrar, you're able to tell them in advance that in a month's time we'll have a service week, and these are the directions. If you file your record of appeal, please ensure that you file your submission so that on the date that you appear before the deputy registrar, it's just a question of taking a ruling date. Yes, yes, my lady. Number 5, I think I will also look at the challenging aspect to me would be, for instance, something to do with the typing of proceedings. If we can also make that as a priority, that will also bring movement, my lady. Yes, my lady. Yes.
The use of ADR, court annex mediation, and AJS.
Yes, my lady, I do agree.
You look at that.
Okay, thank you, my lady.
Yes. Unless other question from the commissioners. Thank you very much. But we also invite you to ask us a question before we bring this to an end. If you have any question.
My lady, I do not have any questions.
Okay.
Yes, my lady.
Thank you very much for your time and for availing yourself for this interview. We will consider your application alongside others, and we will get in touch with you when we complete the exercise.
Okay.
I wish you well, and thank you very much for the work you're doing in the legal profession.
Thank you very much, my lady.
Have a good day.
Thank you.
Commissioner.
I also have a few questions for you. What is your approach to deciding cases?
Sorry?
What is your approach to deciding cases? Philosophy?
Oh, sorry.
Yes,
I
and
not
do you
go-
think it's improper to have a judicial philosophy?
I think it's proper. It's proper to have a judicial philosophy. And my philosophy is I tend toward the sociological school, and I am pragmatic in the decisions that I make. Although I think in our jurisdiction, our philosophy, the way we decide cases and the way we interpret whether it's the constitution
I'm asking
or the
about you as a
mine,
person before going to the...
mine is I try as much as being to look at the law as serving the people and using it for that purpose. So I'm more of a pragmatic jurist.
Okay, and do you think it is necessary for people to have their philosophies known as a judge or a judicial officer?
I think it is.
Why is that?
I think because we make decisions that affect either lives, livelihoods, or people's property, and therefore it's important. It's important for one to have a way of handling things so that it is known. There's no deviation. One day you're doing this, the other one you're doing that. There's a bit of predictability in the way you do things. I think that's key.
And based on the decision you have shared, can we say you are predictable?
I would say so.
Okay. Among the decisions you have shared is one on the one Judge Ibrahim mentioned, the land matter between a brother and a sister. That's sample writing number 4, Joyce Wambeti Kiura versus Peter Mugo and 2 others. If you allow me to just summarize, the fact is, the allegation is that the sister bought land from person B and had the land registered in her brother's name, but she retained the title deed. The brother later disposed of the land without her consent or information. The initial purchaser, the initial seller, appeared in court on behalf of the sister and gave evidence to confirm that indeed it is the sister who gave money to him and he sold the land to the sister. However, in your decision, you took note that the land is registered in the brother's name, so the sister did not have any interest, including trust. What are your views on overriding interest to land?
My view is that even when one says they have trust, the trust should be, in their favor. They will have to bring evidence. It's a matter of fact. And in that case, apart from her saying so, all the other transactions around that property had sale agreements. And if there was land moving from the seller to the person who was registered, and one person is saying, I gave money, the other one is saying it was sold to me and I'm registered, that person, there will be a presumption that the person who is registered is the owner. The other one is trying to dislodge that
I just want you to explain the overriding interest, why we have overriding interest over land, and I know you have applied to be a High Court judge and not an ELC judge, but some of these issues you might find them in family law, especially on issues around matrimonial property. So the overriding interest to land, maybe highlight 2 or 3 of them. Is trust among an overriding interest?
Yes, I would think so. Commissioner for now, they are disappearing.
They have disappeared. So kindly appraise yourself with resulting trust, and there is a Supreme Court decision to that effect. Otherwise, thank you very much. Sorry, you responded to the question by the Chief Justice about independence of the judiciary, challenges that hinder the full realization of independence of the judiciary. And your response was staffing. There is a general concern that maybe 20 years ago, 15 years ago, there were fewer Court of Appeal judges, there were fewer High Court judges, there were fewer magistrates, but the judges, the magistrates worked. Now we have the numbers, but the work is not being done. So what would you say with regards to efficiency, accountability, vis-a-vis independence of the judiciary?
Of course, independence comes with accountability. People have to be responsible. People have to show what it is that they are doing. And a lot has been done now towards, measuring what everyone is doing. And I think even if there is a feeling that people are not working as hard as they used to work then, I don't think that's factual. One of the things that has happened is many matters have come to our courts. Of course, we can do better. We can do better. And I'm sure with the systems we have now, especially now that work is being captured real time, people will be more accountable and more work will get done. And those who are not, working, it will be easier to see now.
Oh, thank you. Thank you, CJ.
Thank you, Chair, and welcome once more, Honorable Ituku. Now I'll ask you only two brief questions. Judiciary has been going through a transformative agenda or journey, including a stage. What catalyst or key drivers do you think would be useful to apply in this transformation journey?
I think especially on stands. One of the things, I would say the key things around stands that will make us move faster is the opening up of the approach of how one gets to court or even gets disputes resolved. Especially when we adopt alternative dispute resolution, when we move many matters to mediation and now to AJS. I think those two, the opening of the means and avenues of getting our disputes resolved will have a big impact in the transformation.
Is there any role that ICT can play to expedite the journey?
A big role, Commissioner. Like now, seated here, I've been appointed to a committee that is dealing with the Mahakama Popote. And Mahakama Popote is based on technology, where we are moving our cases to other courts. And once annexed fully, it will be a big change to the way we are doing our work, and service delivery will really improve, because Mahakama Popote is about access to justice, and those distances can be collapsed. The cost of moving to those courts, or having to move magistrates to where they are now stationed, to the stations where work is. That is a big thing, and technology will really help us.
Fair enough. Now, how does the judiciary contribute to the national development goals of this country?
judiciary has a mandate to be the one to resolve our disputes. And when investors in our country or any country who look at how efficient, how independent, impartial, how the judiciary works, so that I know once I invest in this country, and if for whatever reason there's a dispute, that dispute will be resolved expeditiously, without corruption, impartially, and things will move. As opposed to when people go to courts and monies or projects get held up there. Some of them worth a lot of money because judiciary is not working properly. So a judiciary that works is a judiciary that moves our economy forward and contributes to prosperity. Thank you.
Thank you, Chair. Good afternoon once again.
Afternoon, Commissioner.
Yes, I think most of the areas I wanted to cover with you have been covered by my colleagues. So the only thing I will do is to discuss with you your performance report. From Depop, I believe you must have been served with a copy.
I have.
Yes, we are covering the period from 1st July 2023 to 31st December 2023. Yes, I see the report says that out of the expected contribution of 17%, you have done 16%. To start off, I would want to ask, this is a report from Kerugoya, by the way. I know you recently went to Mombasa, so yes. We are dealing with the Kerugoya report.
Yes.
How many were you in Kerugoya?
By the time I was leaving, we were 5.
5?
Yes.
Now, what is your view about the distribution of work, comparing Kerugoya and other magistrates' court stations countrywide? Do you think you are well-resourced in terms of hands on deck, or do you feel you are not very well-resourced?
I would say we were.
Judicial officers,
for judicial officers, I would say we were. We were well-resourced because by the time I was leaving, we had reduced the remand period to about 3 weeks, so that if a matter is adjourned today, 2-3 weeks will give a date. So I would say Kerugoya, we were well-resourced.
Okay.
Yes.
So could you comment on the report? 16% out of the expected 17%? What was hampering your performance? I was making you lag behind.
That's 1 percentage point below F1S. Because if you look at that statement, it's from July to December.
Yes.
For Kerugoya. The month of November to December, I was already in Mombasa. So there are matters in terms of hearings, in terms of, when there are those weeks I would have been on duty and taking place. So those 2 months, I'm not in Kerugoya. If one could just go back June and back, those percentages would be different. But also, maybe one can also say there is also the issue of administration. But Commissioner, I will not say that because my previous reports showed that I was actually above
the rest.
Yes, above the rest.
Okay, that explains it. But now you are in Mombasa. How are you managing balancing your administrative duties vis-a-vis the actual judicial work, the core function? Remembering that Mombasa is also a very heavy station. How are you managing that?
What happened when I went to Mombasa is that I found that they have divisions. There is civil division, there is criminal division. I inherited the docket that was held by my predecessor in the criminal division. We held a meeting with my colleagues in the criminal division, and we agreed that I cannot be taking plea every other time, all the time. So we have a duty roster. So they take a bit of the load off me. And there is also the issue of being the chief magistrate. And I think the one that follows me is SRM. I get to hear the ESCC matters. So we also...
The immediate follower is at SRM?
No, in the criminal division.
Yes.
There are other ranks in the other divisions. we agreed that we can also organize our work in such a way that, because there are matters that will come to me because of jurisdiction, like the ESCC matters, those come to me, those others go to them. But we've organized it in a way that I will not get overloaded. People will not have their matters delayed because of my administrative duties, but it will also pick some weight of me, considering that.
Okay.
Yes.
Okay, thank you very much, and I wish you well.
Thank you.
So it's not on yet. Fine. Article 73 talks about the responsibilities of leadership. Can you tell me what they are? Article 73 of the Constitution. If you can't recall that, you can go to...
Sorry, I can't recall right, sorry.
Yeah. Yes. Okay, what are the guiding principles of leadership and integrity? That's fairly general, and it's also chapter 6. You are a leader in your station, isn't it? You
Yes.
said you are in...
Yes.
You are the head of station
Yes.
in Mombasa.
Yes.
Yes. But you know the guiding principles of leadership and integrity under the Constitution.
Commissioner, I know them.
But they disappear because you are appearing before
I don't want to say
commissioners.
I don't want to say that, but yeah.
Okay, fine. Then let's look at, you know generally about leadership, and there are leaders who are transformational and others who are probably not.
Yes.
What would you consider yourself as?
Commissioner, I consider myself transformational. In that, in the places I have served,
Yes.
I have transformed the way of doing things. And judiciary, it's about service delivery. So I've been able to influence the judiciary staff and my colleagues towards a service delivery that addresses the needs of the people. So I consider myself a transformational leader.
Okay. In your career, what can you describe as your key achievements as a leader? You just told us a few minutes ago that you got inspired to join the judiciary to do a few things differently.
Yes.
What are those things you've done that are different from probably what was going on, which you can pride yourself in?
Thank you, Commissioner. My first station that I headed was Maralal in Samburu. And I can say one of the things I take pride in about my leadership is Maralal is that when I went there, they had a mobile court in Baragoi and another one in Wamba. But they would go there a month, they would go there for 6 months. We were able to put structures so that it became predictable. And I would say that is something I've done in all stations where I've headed, where I put structures that are predictable, that are accountable, and anyone coming after me will be able to work around them. I also mentor officers who work under me, and I'm proud to say that there are 3 officers, magistrates who have worked under me, and after that they have become heads of station who have won awards. And I look at them and say, it started with us, and I think they are doing very well.
Thank you. Just refresh your mind on those other questions.
I will, Commissioner.
Thank you.
Thank you, Honorable CJ. Honorable Ithuku, maybe you could tell us of a time when your integrity was put to test and perhaps how you went about it, any lessons that you drew from the incident, if any.
Thank you, Commissioner. What happens mainly in the work we do is that corruption thrives where systems are opaque. And if I can say as an example, and this is something that can happen and happens, is that there was a time, you have a matter that is before you, there's an application, and sometimes an advocate will want maybe to have something clarified or to say, when I'm in chambers, maybe I'm told by the office administrator, this so and so who wants to see you. And I know maybe we just had a matter with that advocate. And you see, integrity is also about perception. And what I said in that case is, get the advocates on the other side, because we just come from court. Come in with the advocate, discuss what it is, mention what is it that you wanted to mention to the court in his presence. He gets to hear and maybe he gets to respond. And it's about openness, because when I said that, they came and you realize there's nothing that big that would not have waited maybe the ruling, and you get that impression, because sometimes it may be that there was even nothing to tell me. All that was needed was the impression that he has accessed my office and got out. That would have created that something has happened. But if they just get in together, that story cannot fly. And I would say that's how I handled it. And that's something you just get to learn, that so long as there's openness, people are transparent in the way you're doing these things, some of these things will not be there.
Okay.
Thank you.
If you're successful to become a judge, there's a certain way you're expected to conduct yourself. Maybe you could tell us any restrictions on activities of state officers?
Yes, if I am appointed, because some of the restrictions still apply to me as a judicial officer, is that I cannot be a judge and I'm openly involved in politics, in activities that clearly show that I belong to one side and not the other. So my activities are to be restricted. Even my private life, I will have to handle my private life in a way that does not bring disrepute to the office or make people feel that I could be partial or working with one side and not the other.
So you've given us one restriction on political parties and your involvement. Any other, maybe two? Just two more.
Also active involvement in just businesses, trading in a way that is open and could easily bring conflict when matters come to us.
Okay. Maybe you will refresh on that. My final question, I know you've been head of station for quite some time, and you've worked with the millennials or the young people.
Yes.
Maybe tell us what is the place of millennials in the institution and how you would go about dealing with them to ensure that their performance is at optimal levels.
One of the things I've done, because I have them, is to understand them and to understand that their worldview is different from ours or the people who have gone before us. And millennials, most of them are tech savvy. They grasp some of these things very fast. And we can put them in that space where those services are required. We can configure our operations in a way that responds to their talents and their skills, then as an institution we can really benefit. There are some structures that maybe have worked before and are not working for them. So I would say that is we understand them and we structure the organization in a way that allows them to work, especially when you're talking about adopting technology, being more flexible in the way we work, because previously it has to be this, if not this a letter. But you realize that if you are flexible, maybe the production will still be what you wanted, maybe not in the hours you wanted. That's what I would say.
Thank you very much, and I wish you the best.
Thank you.
Just to conclude on that, how have you used millennials in your court?
Mombasa law courts. We are having a problem with typing of proceedings. And one of the things that we keep complaining about is lack of typists, people who are designated as typists. Most of these millennials who are coming, they can type faster than most of them. So we have agreed with them that you don't have to be designated as typists. Get this file, type it for us, we have it then proofread. And that has turned around our waiting time in terms of, taking files to the High Court. That's what we've done.
Well done. This brings us to the end of the interview. Thank you for availing yourself. We will get in touch with you when we complete the process. But before we release you, we always give an opportunity to a candidate to ask us a question, if you have any.
Thank you very much, Your Lordship. I don't have a question, but I want to express my gratitude for being invited. Just coming here and having this conversation is enriching and gets, I'm sure, me to know what is in the judiciary working. It could also be a feedback mechanism for the Commission to know what we are doing. And I am grateful and hopeful that I'll be able to satisfy the Commission. Thank you very much.
Thank you. All the best, and keep up the good work that you're doing to serve the people and to find out what is good for the people. Have a nice afternoon.
Bwana, iko shinda gani Masai?